Throughout history, nation-states have protectively guarded their legal systems and the way in which their courts and police forces have operated. In contrast, international law has been weak, with very few effective powers. It has acted more as a guide and a symbol rather than a practical means of either enacting or enforcing law. Globalization, however, appears to be changing to this situation to a certain degree, with new global legal institutions and norms being developed in response to macro-level changes. Like everything else, crime is operating more at a cross-border level. The influence of globalization on law can be seen in many different areas, such as the regulation of trade and investments, the protection of human rights, and the international criminal responsibility of individuals, intellectual property, security and environmental governance, and the safeguarding of the diversity of cultural heritage. The legal relationship between states is one area which this course has already touched on, when the political dimension of globalization was discussed in Lesson 4, within the context of the potential breaking down of the Westphalian model of sovereignty. Under this model, according to Ralph Michaels, the central notion is that the state presents the ultimate point of reference for both domestic and international law. In this model, all domestic law is the law within one state, whereas in international law, the only actors are states and the supranational institutions that states have set up. One key aspect directly linked to this notion of sovereignty is citizenship. Historically, citizenship has arisen not out of culture, ethnicity or language, but of law. States determine citizenship, and to be a citizen of a nation-state creates particular rights and obligations to the state, an idea enshrined in the works of early political theorists such as John Locke and Thomas Hobbes. The citizen may be bound, for example, to pay taxes or be allowed to vote in elections, and in return the state provides defence and a functioning judiciary. The forces of globalisation, specifically the significant increase in global migration, has impacted considerably on this notion. In many cases, national identity is a matter of choice rather than birth. Increased globalisation has also resulted in the increased incidence of multiple national allegiances. The notion that you can be a citizen of more than one state, or a member of one state and a wider supranational body, for example, the European Union. As a result, the relative importance of national identity has diminished. The rise of cross-border networks, as discussed in Lesson 5, has also led to the increased importance of non-state identities. Rather than seeing themselves solely, or at least primarily, as British or American or Indian, a person might identify themselves first and foremost as a Manchester United fan, a vegetarian, a Muslim, or indeed a global citizen. The rise in cross-border networks has resulted in legal processes having become more globalised, specifically with regard to crime. Historically, where crimes would largely take place within a specific physical jurisdiction, a clearly defined area of land which a state had legal control over, such matters could be dealt with internally. In a globalised world, however, crime is an international affair, whether it be terrorism, refugee smuggling or banking fraud. This can lead to situations where states apply their laws extraterritorially, i.e. applying their national laws outside of their own jurisdiction. Whilst for some this is a positive, for example, seeing the USA in its rightful place as the world's policeman, it can also be seen as an illegal abuse of power. Something else which does not obey human-made physical borders is the impact of climate change and pollution. As discussed in the previous lesson, rising sea levels, declining freshwater supplies, desertification and acid rain do not stop at national borders and are not purely domestic affairs. Individual states are largely powerless to do anything legal about this by themselves, since the cause of specific problems may be another or many other nation states. As such, a global legal framework agreed upon by a concert of nations is needed to deal successfully and effectively in such circumstances. The final area to focus on in this lesson is the International Criminal Court, or ICC. The ICC is an intergovernmental organisation established in 2002, which is based in The Hague in the Netherlands. As of 2016, there are 124 states which are party to the Rome Statute, the foundational and governing document of the ICC, meaning that they are full members. The overriding purpose of the ICC is not to supersede existing national justice systems, but to complement them. Over the course of its history, it has generally only operated under specific conditions. For example, when national courts are unwilling or unable to prosecute criminals, or when the United Nations Security Council or individual states refer investigations to the court. Its focal areas have predominantly been on genocide, the mass killing of a national, ethical, racial or religious group, crimes against humanity, such as murder, rape and enslavement, and war crimes, including torture and the denial of a fair trial. Geographically, its work has looked at cases in countries such as the Democratic Republic of the Congo, Uganda, Sudan, and Kenya. The ICC has come in for considerable criticism since its inception, with some making accusations of its Western imperial nature, punishing leaders from small, weak states, while ignoring crimes committed by richer and more powerful states. Others are concerned about whether those accused by the ICC have sufficient rights. Lastly, although 124 states are members of the ICC, it is the absentees from this list which are perhaps more noticeable. This group includes the USA, China, Russia, India, and Indonesia. To conclude, we can see that the law has been influenced in many different ways by globalization, and this is likely to continue to be the case. In the future, some have argued in favour of expanding the notion of the ICC and creating a World Court of Human Rights, a forum which would recognise the notion of fundamental human rights and would offer a mechanism for defending them. Clearly, this would be a controversial notion given the conflicting conceptualisation of rights in the individual legal systems of nation-states. One further area where the influence of global law is likely to be tested in the future is over that most contentious of issues, namely land. Whether these disputes are over existing plots of land where there is disputed ownership, such as the territorial disputes over islands in the South China Sea, or over areas of land where there is shared ownership, but where there are many huge untapped natural resources, such as Antarctica, or indeed over land which is beyond the Earth, primarily the Moon and Mars, whose ownership may become an issue in the years to come.